Just learned that I can put people in timeout on YouTube. I never knew that. Are we missing anyone?
Not from the department, Your Honor.
We don't gonna have, I don't think we have mom or dad here. Usually we don't.
I don't expect mom, Your Honor.
Okay.
And I don't expect Mr. Sanchez.
With that, then, Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Riley Sherrod Buckner, pregnancy specialist for the case.
Kathleen Savage, attorney for the respondent mother, Miss Samaniego. Not ready, Your Honor. No contact.
Irene Acosta, attorney ad litem, appointed to represent Jesus Sanchez. I'm announcing not ready, Your Honor. I have not had contact with him.
For Harris, attorney and guardian ad litem for the child. I'm ready, Your Honor.
Not ready's are overruled. We're going to move forward with the permanency review. We're 3/4 of the way of this case, and I don't think mom or dad have showed up for anything since the beginning, back in April, and then dad waived service. So we'll move forward, but I understand that neither one of you had contact. So, all right, Miss Sherrod Buckner, I did review your report yesterday, and it looks like permanency goal at this time still relative adoption with Miss Martinez.
Correct.
And the placement there is safe and appropriate.
Yes, sir.
And it's in the child's best interest to remain there.
Yes, sir.
And that is the least restrictive placement possible.
That is correct.
And then Andres is up to date on his checkups
Yes, sir.
and not receiving any kind of medication.
He does receive.
Not psychotropics, rather.
No, sir.
I know he's on a couple of things for, is it allergies?
Yes, that he get as needed, and then he takes propranolol.
Okay. And then he's got no type of therapy or anything like that. He's on target.
At this current moment, yes, sir.
And at this time, is he having any contact at all with either parent?
No, sir.
And neither parent is in compliance at this time?
That is correct.
Have you been in contact with either one of the parents since you filed your report?
I have been texting them, but I have not received a response. No, sir.
Have they made their intentions clear to you at all?
No, sir.
Is it safe to return the child to either parent today?
No, sir.
And has either parent addressed the concerns at this time?
No, sir.
You believe it's in the best interest of the child to remain in the temporary managing conservatorship of the department or belong?
Yes, sir.
Ms. Kyler Green, questions for Ms. Sherrod Buckner?
Yes, Your Honor. Thank you. So does the child, he's been diagnosed with tachycardia?
That is correct.
Okay. And that's, it's somewhat benign if it's taken care of. Is that right?
Yes, ma'am.
Okay. And how often does he see a cardiologist?
Yes, I do believe he see the cardiologist every 3 months.
Okay. And is everything going according to what they would hope to see?
Yes.
Okay. And the dad did complete DNA. Is that right?
That is correct.
Okay. And I don't remember if we discussed this at the last hearing, but he was determined to be the father?
Yes, ma'am.
Based on the DNA?
Yes.
Okay. And in attempting to locate the parents, I understand you said that you have been texting them. Have you talked with any family members in an attempt to locate the parents?
Yes, I have.
Okay. And for both?
Yes.
Okay. And have you made any headway when it comes to speaking with relatives?
For Miss Samaniego, I do speak to her mother consistently every month or every so in between month, depending on what has been brought up. I have spoken to Miss Samaniego over the phone because Miss Martinez did let me know that she was staying in a camper that I did go out to, and I waited on her, but she never showed. Far as Mr. Sanchez, I have spoken to his sister, who he is currently residing with right now, and I also have been out to the home. And when I did go out there, he wasn't there. That's what she did report to me.
Okay, but when it comes to speaking with them telephonically, they're not responding?
No.
Okay. Have there been any changes to their family plan of service
No, ma'am.
since the family plan that they already have a copy of?
Correct.
Okay. And I think it might have been way back in August, parenting classes were maybe being taken by the parents?
No, they was ordered to engage in parenting classes through SA for Fatherhood, which they have yet to engage into.
Okay. When mom is not taking any drug tests?
No, ma'am.
Okay, so I noticed on your report it said for November 30th, it said pending. What does that mean?
So the way I have been trying to communicate with Ms. Samiego is through via text. And so I send her, I tried to send her to do a UA. And the reason why I say I'm pending, because I have to wait until the system triggered to see if it's a no-show or if the collection has been, or if a sample has been collected, sorry.
Okay, and if there is one way or the other, will you inform the parties?
Yes.
Okay, thank you. Your Honor, I have nothing further.
Ms. Savage.
Yes, what other services does mother still need to engage in?
At this current time, I know that she needs to engage in individual counseling, continue to do UAs and hair tests for us. I do have her listed to receive a psychological and also a psycho assessment. And then she will also need to engage in parenting while also trying to do weekly parent-child visits.
Okay, and have any visits been set up for her, or has that not happened since you haven't had communication?
I do believe the last one was back in May, but since then we have not had any visits with mom.
Okay, and the phone number that you have for her, have you called or do you just text the number?
I do both. I call and text.
And she hasn't responded to either one?
No, ma'am.
Has Miss Martinez confirmed if that's a good number for Miss Samaniego?
Yes, ma'am.
Okay, and has Miss Samaniego made any recent contact to your knowledge to the placement, Miss Martinez?
I know that she does speak to her mother. I do believe the last time I spoke to Miss Martinez, she just told her family happy Thanksgiving. That was the last thing that was reported to me. But far as coming over things like that, no, ma'am.
Okay. If you get any additional or new contact information from Miss Samaniego, would you be able to provide that to me?
Yes, ma'am.
I'll pass the witness, Your Honor.
Ms. Acosta.
What services does Mr. Sanchez still need to engage in?
Yes, ma'am. So he is aware that he needs to do random UAs and hair tests. I do have him scheduled for individual counseling. And then I also have him scheduled for a psychological assessment along with the psycho assessment. And then also ensuring that he also engaged in those parent-child visits.
And when was the last time you spoke with him?
If I'm not mistaken, it had to been maybe right before Halloween. That was in person.
Okay, and did you provide him a copy of his service plan?
Yes, ma'am. I have emailed it to him.
Okay. And did he acknowledge receipt of it?
Yes.
How did he acknowledge receipt of it?
When I did speak to him back in October, that's when I did send him the last acknowledgement for the family child plan of service. When I did speak to him when we met face to face, he did. But this upcoming one that I just sent out, he has not responded to any of my emails.
Okay, thank you. I'll pass the witness, Judge.
Ms. Harris.
In your past communication with both parents, do you believe that they understood what was expected of them to achieve reunification with their son?
Yes, ma'am.
Are you aware of any mental or physical challenges that would prevent them from being able to achieve those services?
No, ma'am.
Anything that would prevent them from understanding what is expected of them?
No, ma'am.
Is there anything else that you could do or belong could do in order to pursue reunification with either parent?
No, ma'am, not at this current time.
Have you used every resource that you know available to you?
Yes, ma'am.
And can you state again what the goal is for this case?
Yes, ma'am. Relative adoption.
And that is with his maternal grandmother, correct?
Yes, ma'am.
And are there also biological siblings in the home?
Yes, ma'am.
So this is a goal that would allow him to remain with family?
Yes.
And you believe that's in his best interest?
Yes, ma'am.
No further questions, Judge.
Any follow-up?
No, Your Honor, no other witnesses.
Anybody else have a witness?
No witnesses, Judge. I did need to address the court
Go ahead.
regarding my client briefly. I know at the last hearing it was ordered that if he didn't provide income information, then I would be dismissed, but I never received a dismissal order or anything stating I was dismissed. And so I wasn't sure if I was going to be continued because I don't believe he has provided that information.
Well, that was one of my questions too. I've got a note back from September the 12th that if they didn't provide any employment information, that I would find that they were no longer indigent and dismiss attorneys. Or father, sorry, not the mother, but just the father. And I don't believe I ever got anything. So I just wanted to give you the opportunity, and Ms. Sherrod Buckner, the opportunity to tell me in open court whether you received anything. So
I have.
okay. So I have no, and I'll deal with that in a minute, but what I was looking at back in September is that I've got no information to verify that he is in fact indigent and qualifies for counsel, and he's not participating in this hearing. So I'll address that in just a moment. Ms. Harris, anything else that you want to bring before the court?
No, Your Honor, he's doing great where he's at. He's surrounded by family and loved and well taken care of. He does have the heart condition and is taking medicine, but should be off, has an appointment coming up to start seeing about being weaned off. So he's doing good. Everything's being taken care of.
Good. Glad to hear it. Okay, then the court will find, for the purposes of the permanency review before final order, that the permanency goal of relative adoption with Ms. Martinez is in the best interest of the child. And thank you, ma'am, for what you're doing. Greatly appreciate it, and we all do. Court finds that his placement is safe, appropriate, meeting his needs, and in his best interest to continue, and that it's the least restrictive placement available. Court finds he's up to date on all of his checkups, and his medical conditions are being appropriately addressed. He's not receiving any psychotropic medication, he's too young, and he's not receiving any type of therapy at this time. Court finds that for all intents and purposes at this time he is on target. Court finds that neither parent is in compliance with the family plan of service. Neither parent is maintaining contact with Ms. Sherrod Buckner or their attorneys in this case. Court finds that no changes have been made to the family plans of service since they were provided copies. Court will make finding that Mr. Sherrod Buckner has been texting the parents and has received no response from them. And that as of today, it's not safe to return the child to either parent. And that as of today, neither parent has addressed the concerns that brought the child into the care of Along. It's in the best interest for Andres to remain in the temporary managing conservatorship of the department at this time. Because the parents are not keeping in touch with their attorneys either, and because the court has no way to establish that Mr. Sanchez is in fact indigent, the court is going to find that there's no way for the court to conclude or make a determination that he's indigent, and therefore the court will dismiss Ms. Acosta from representing Mr. Sanchez, as he has not appeared before this court in opposition to this case at any point in time. I really don't want to dismiss anybody at this point in time because I have a feeling we're going to need something in the future, but I can't keep him on or keep you on representing somebody who's not using your services and who may not be indigent. All that being said, if we get to a point where you all believe a mediation would actually be fruitful, I don't know that it will be. Please let the court know, and I can put Ms. Acosta back on just for mediation purposes, but I'm not going to continue her at this time and force you to continue to work a case where you don't even have a client that might be indigent. As far as the mother goes, back in September, there was enough information for me at that time to find that she was indigent. I don't know if anything has changed, Ms. Sherrod Buckner, but it sounds like her situation hasn't improved at all. Correct?
Yes, sir.
All right. Okay, then that will be the order of the court. We'll be back February 13th, 2024 at 9:30.
Your Honor,
Yes.
I understand your findings for the texting and not receiving a response. I'm assuming that's in regards to reasonable efforts by Belong. I'm just requesting a finding that she's beyond texting. She's also visited relatives' homes in an attempt to visit with them.
Yes,
Or
that's
contact.
correct. And I did hear that testimony. I will make that finding as well that Mr. Rod Buckner has made attempts in person as well. And I will find that Belong has made reasonable efforts. Okay, then we'll see you back February 13th at 9:30. Nothing further, all 454th Judicial District Court of Medina County, Texas. Court is hearing this case from Kendall County, Texas. Is there any objection?
No objection, Your Honor.
No objection.
With that, Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Katarina Lewis, Belong Permanency Specialist.
Irene Agosta, attorney for the child.
Your Honor, I just heard back from him. He was not planning on attending unless he needed.
Oh, that's fine.
Okay.
Anybody else that needs to announce? I think that's it. Thank you. Reviewed your report. Permanency goal at this time, relative adoption with Ms. Wells.
Yes.
Out there is safe, appropriate, meeting the needs of the child.
Yes.
And this is Serenity's least restrictive placement.
Yes, it is.
And she is up to date on everything.
Yes, she is.
Any issues at all, health-wise?
Not health-wise.
Any issues otherwise?
No issues. She's just engaged in speech therapy, occupational therapy, a lot of therapies right now. So just keeping up with those.
And you believe that those therapies are appropriate in addressing the concerns?
I do.
Okay. And is she receiving any type of medication right now?
No.
All right. And at this time, are there any known barriers to achieving the permanency goal?
At this time, we have been notified that Mr. Emilio Del Toro, the biological father, did put an appeal in. We are waiting on an update on that. I do know back in October it was received, but we don't have an update as of that right now.
Okay. Any specific reasonable efforts that Belong has made?
Yes, we are actually transferring the case to adoptions today. So this case will go to adoptions to hopefully get Serenity adopted. We also have requested, well, we have a HESIC back and a redaction as well. So that should move the process along once we get the appeal back.
Right. Okay. Ms. Kyler Green, do you have any questions for Ms. Lewis?
Just one, Your Honor. Ms. Lewis, we from the department and have reached out to the appeals court to request an update. Is that right?
Yes.
Okay, so we're just waiting on confirmation from them that the whether or not the appeal's been overturned. Or the
Yes.
case has been overturned. Okay. Okay. Thank you.
Ms. Acosta?
I have no questions, Judge.
Anything else, Ms. Kyler Green?
No, Your Honor, and I just to let the court know that I've informed the other parties anytime I get an update on this case, so everyone is kept abreast of the situation.
Okay. And I did have a note here in my system that there's an appeal pending. So, Ms. Acosta, anything you want to add?
No, Judge, the only thing holding up the adoption is the appeal, so we're just waiting on that.
I think she froze. Okay, you froze for a second, but I think I got it all.
Yeah, my internet's wonky today. I'm not sure what's going on.
Then for the purposes of the permanency review for final order, the court finds that the permanency goal of relative adoption is appropriate and in the best interest of the child. Court finds that placement is safe, appropriate, meeting the child's needs, and in her best interest to continue. Court finds this is her least restrictive placement available. She's currently receiving speech and occupational therapies, and she is up to date on her medical, dental, and vision. And court finds that those concerns are being appropriately addressed. Court finds that the only known barrier to adoption at this time is the appeal, and that Belong has made specific reasonable efforts, including transferring the case to adoptions as of today and receiving the HESIC and the redaction. Next hearing will be May 14th, 2024 at 10 a.m. May 14th, 2024 at 10 a.m.
Your Honor.
Yes.
I just heard from Mr. Saldivar again. I don't know if Ms. Wells has anything that she wanted to report or she just wanted to be here, but just since she's here, if there's a moment for her to speak, I don't know if that's okay with the court.
It's fine. Ms. Wells, anything?
No, nothing really.
It was your big moment.
I'm
This
just
was your
happy.
big
Like,
moment.
we're almost there. We're almost there.
All right. Okay. Then I'll see you all back May 14th, 2024 at 10 a.m. Thank you all for your time and your service. If nothing further, all parties of Falls Judicial District Court of Medina County, Texas. Ms. Kyler Green, would you please begin the announcements?
Morning, Your Honor. Emily Kyler Green, attorney for the department.
Yeah, sorry. Corlin Valle for Belong, the caseworker for Stephen.
Alana Pearsall, child attorney and guardian ad litem, I'm ready.
All right, we're here for permanency review after final order. I didn't see a report on this, maybe I missed it, but I think I have the information I need based on my understanding of this case. And if anything has changed, just let me know. Is the permanency goal still unrelated adoption?
Yes, sir.
And is his placement safe and appropriate, meeting his needs?
Yes, sir.
And is it in his best interest to remain in his current placement?
Yes.
All right. And is he up to date on all of his checkups?
Yes, he is.
And are his psychotropic medications current on their review?
Yes, they are.
Okay. How are his behaviors right now?
He's doing really good. No incidents in placement or at school.
Okay, that's good. Still on tear?
Yes.
Has he had any recent inquiries?
No.
Any movement at all?
No. No inquiries whatsoever.
All right. Have you all had any meetings with him recently?
We did have a circle support September 20th. And PALS has started to reach out to start PALS classes with him.
Okay. Have you discussed adoption with him recently?
We have originally he was open for adoption, open to adoption. In November, he did tell me that he is no longer willing to be adopted, that he wants to go to sister Catherine Heron. And if he's not able to go with her, then he's just wanting to age out and then go with sister.
Okay. Is the sister appropriate?
She's appropriate. They've started face-to-face visit with each other. They're actually placed about 5 minutes away from each other. So they're visiting weekly. She is quite young, starting off on her own, got her own apartment with a roommate. Does have a stable job, but no driver's license or vehicle. She said to herself, or she did inform me that she's hoping to look at being possible placement for Stephen in about a year when she's got herself settled.
Okay. All right, we can talk about that more in a minute. Is he passing all of his classes right now?
He is.
Are his educational needs being met?
Yes.
Did he ever get his ID?
Not his ID. He is working towards his driver's license, and during that circle support, the associate stated that he could wait until he got his driver's license for the ID.
Okay. Do you think that you all should have a meeting or staffing about his permanency goal?
Yes.
Okay. Ms. Kyler Green, you have any questions for Ms. Valle?
What's his level of, yes, Your Honor, thank you. What's his level of care currently?
Moderate.
Okay, and it's maintained at that?
Yes.
That's all I have, Your Honor. Thank you.
Pearsall?
No questions.
All right. Any other specific reasonable efforts, Ms. Valle, that Belong has made towards achieving the permanency goal?
Yes, he is currently published on Terra Tap, Adopt His Kids. I also sent in a referral to Wendy's Wonderful, which has been accepted. It's just on pause right now because the Wendy's Wonderful through Upbring is moving position, so they're needing to fill that position.
Okay. Ms. Pearsall, what are your thoughts?
Judge, he's doing really well. He is in a wonderful foster home. They definitely are meeting and exceeding all his needs. He loves it there. They do a really good job with teenage boys in general. He's in driver's ed. You know, he has friends, he has support. He goes to a smaller school, like a charter school. He's doing really well. I don't have any concerns. I think he'll do well. And if his sister is an option, you know, we can keep working with that and looking at it. And honestly, if he just out in that home, that's okay too. He'll have support for the rest of his life.
Okay. For the purposes of the permanency review after final order, the court finds that the permanency goal of unrelated adoption is appropriate at this time. However, I'm going to order the parties to staff the issue of the permanency goal, whether or not it is appropriate moving into the future, and then to develop a plan to work with Stephen's sister as we move through the next several months. He's still only 16. He won't be 17 until next year, next October. So I feel like the timeline is right. If she's serious, to sit her down and tell her, we've had your brother on these registries for a while. I mean, I'm looking back to the notes, and we've been doing this for a while. If you're serious about being in his life and being a support for him, and I agree with Ms. Pearsall, I think that, I mean, obviously that could be a long-term, lifelong relationship. Then we need to know what she's willing to do, and if she's willing to put herself on a timeline. Because what I don't want to do is put the idea in his head that that's an availability or a possibility, and then her fall off the map because we didn't communicate with her well enough that we were taking her seriously. So if she's willing to come sit down with everybody, I'm going to order the parties to staff with her and look at the reality of it to determine whether or not it's an option. And I really hope that it's conveyed to her that it's kind of our only option at this point, because we don't have an adoptive placement and this foster home is not an adoptive placement. So, but for the point or this point in time, I find that his placement is safe and appropriate, meeting his needs in his best interest to continue. Find that he's up to date on all of his checkups. His psychotropic review is up to date. Find that his behaviors are good right now. Find that the circle of support took place and that he will be beginning PALS soon. And then I'll find his educational needs are being met and he is in the least restrictive placement possible.
Your Honor,
Yes.
can you please make a finding as to the reasonable efforts?
Yeah, I was getting there next. I just needed to write my note real quick. I'll find that the Belong has made reasonable efforts towards the current permanency goal because he's listed on several registries, and then there's been a circle of support held, and he's set up for PALS. But again, as we move forward, I really think we need to reconsider what we're looking at as far as the permanency goal. And I'm really hoping that his sister is willing to participate. Well, we'll see how that goes. Our next hearing is set for May 14th, 2024 at 10:30. May 14th, 2024 at 10:30. I'm not going to order a progress hearing, but I would like an update to the court. So I'm going to order an update to the court by mid-January as to what's going on with his sister and what the parties were able to accomplish as far as a plan. Because I kind of feel like he's been in a holding pattern for a long time. And I want to get him out of it. If we can. Maybe we can, maybe we can't, but I want to try. Okay. Anything further?
No, Your Honor, thank you.
Okay. Well, thank you all for your time and your service. If nothing further, all parties are excused.
Objection, Judge.
Thank you, Judge.
All right.
Thank you.
Then with that, Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Christy
Lorna
Hunt,
Gen-
permanency supervisor with Belong.
Lorna Gentry-Mann, permanency specialist with Belong.
Anna Swallow, attorney ad litem for respondent father Michael Rodriguez. Ready? Mr. Rodriguez, please unmute and state your name.
Michael Rodriguez, yes, I'm ready. Rochelle Acevedo, I'm standing in for Richard Saldivar for Dad Zachary Sanchez. And Judge, I believe the jail was going to get him on. I don't know. There's a 361. I don't know if that's.
Yes, ma'am. This is Zachary Sanchez.
Deborah Fuller, attorney and guardian ad litem for the children. Ms. Acosta said that she will be on in a couple minutes. She's in another courtroom.
Anybody else has not announced?
The
If
mother
you're not,
did. The
I'm
mother
sorry.
didn't. The mother didn't announce.
Ms. Duarte, would you please unmute and announce?
Alexis Duarte.
We're here today for a final trial, and I understand the parties have an MSA. I reviewed that prior to today's hearing. And then there's also a motion for a name change on file.
Yes, Judge, I filed that following the mediation.
And it is not timely filed. We did not receive 3 days notice, but.
Judge, I filed it on last Thursday, I think, or Wednesday.
And so Monday and it's Friday and Monday are 2 days. It's 3 days, not including the date of the hearing.
Well, Judge, I'm requesting it. I don't think it's going to cause any sort of prejudice or anything like that. I know my client's already reached out to the mother to try to confer on it. His child is his child. He discovered that during the pendency of this case.
Okay. Well, let's take the MSA first, since we all are on the same page there, from what I understand. And Ms. Kyler Green, what I would like you to do is state the terms of the MSA on the record with the MSA as an exhibit. And I don't know if you have any other exhibits.
I do. So, Your Honor, I know that you said you reviewed the MSA, the I guess, logistical issues of the MSA that I don't know if they should be addressed first or during, but the parties agreed to sever this case, and for the ease of the AG's office when it comes to the child support that's been agreed upon in the MSA for Michael Rodriguez, we have, I think it's been submitted to the court already, a request for severance. Okay, so I don't know if that makes it more or less complicated, Your Honor, but the MSA and the exhibits are with the current cause number, not the severed cause number. So just to avoid confusion, I just want to make sure the court is aware of that.
I think what we have to do procedurally, since the MSA severs the cause out by agreement, is that we have to get the MSA entered, and the court needs to order whatever the MSA has ordered, which includes a severance, and that severance would occur after.
Okay.
And so the order of filing would be, obviously your MSA has already been filed, and I guess it just depends on the relief in the MSA that applies to the severance, and we'll get through that as we go. But it sounds to me like that. I don't know if somebody else has another opinion. Anyone? No? Okay, then let's go ahead and go through the mediated settlement agreement. Ms. Kyler Green, please.
No objection, Judge.
Having heard no objection, the court will admit petitioner 6 and Ms. Kyler Green. You can probably skip the boilerplate on the first page and just get into the heart of the agreement, please. And let's go ahead, since there's a lot of detail there, I want to have it read verbatim into the order, please.
Understood, Your Honor.
The record.
Thank you. So it says Exhibit A, this agreement is not subject to revocation. Number 1, this matter shall be severed into 2 matters, 1 for each child. Number 2, the matter concerning the child shall be dismissed. Number 3, the following provision shall apply to the child, Miele. A, DFPS, attorney ad litem, shall be dismissed at the final hearing on December 12th, 2023. B, Alexis Duarte shall be named sole managing conservator of the child with a geographic restriction to Atascosa, Bexar, Medina, or any contiguous counties thereof. C, Michael Rodriguez shall be named parent possessory conservator of the child. D, possession and access by Michael Rodriguez shall be as follows. Number one, for the child's birthday, 2023, Michael Rodriguez shall have possession of the child from 11 a.m. to 3 o'clock p.m. Number two, from the date of today's agreement through January 31st, 2024, or for 5 complete weekend visits, both Saturday and Sunday, whichever is longer, visitation shall occur on the first, third, and fifth weekend of the month from 8 a.m. to 6 p.m. on Saturday and 8 a.m. to 6 p.m. on Sunday. Number three, Michael Rodriguez shall have holiday possession of the child from noon to 6 p.m. on Christmas Eve, 2023. Four, after the 5 visits in step 2, or from February 3rd, 2024 through March 31st, 2024, and for 5 complete weekend visits, whichever is longer, visitation shall occur on the first, third, and fifth weekends of the month from 8 a.m. Saturday to 6 p.m. Sunday. Number 5, after the 5 visits in step 4, or beginning April 1st, 2024 through May 31st, 2024, and for 5 complete weekend visits, whichever is longer, visitation shall occur on the first, third, and fifth weekends of the month from 6 p.m. Friday to 6 p.m. Sunday. Number 6, should Michael Rodriguez not exercise 5 complete visits in each steps 2, 4, or 5, he shall not proceed to the next visitation step until he has exercised the 5 complete visits in each step. Number 7, after the 5 complete visits in step 5, or beginning June 1st, 2024, Michael Rodriguez shall have a standard possession order of the child. However, weekend visits shall occur throughout the summer of 2024 with 2 one-week non-consecutive periods of possession by Michael Rodriguez, with 1 week during the month of June and 1 week during the month of July. Michael Rodriguez shall designate his weeks of possession by April 1st, 2024, or weekend visitation shall continue through the summer. E, standard possession order pickup and drop-off provisions for the child shall apply. Pickup and drop-off may occur at the nearest police or sheriff's office at the request of either party. F, beginning January 1st, 2024, Michael Rodriguez shall pay guideline child support through the Texas Office of the Attorney General. G, Alexis Iturte shall ensure the child is on government-sponsored medical, dental, and vision insurance through the Texas Office of the Attorney General. H, beginning January 1st, 2024, Michael Rodriguez shall pay $25 per month medical support through the Texas Office of the Attorney General. I, all insured medical expenses shall be split between the parents 50-50. And J, the loving and caring order and the children's bill of rights shall be attached to the final order. And this was signed by all parties and served.
All right, without getting into the name change or anything outside of this agreement, I want to make sure that I have it on the record that this is the agreement that you all made. Ms. Acosta, this is your understanding of the agreement?
It is, Your Honor, and we were going to get testimony with regard to the guidelines.
Okay, and that was another question I had as far as making sure we had a specific order leaving here today. All right, Ms. Acevedo, did Mr. Saldivar give you any indication as to his position on the MSA?
He just indicated that I guess Dad did not participate, but he didn't have any objection. It was his understanding that with regard to Mr. Sanchez, obviously that portion was going to be non-suited, and so his rights were not going to be affected. So there was no objection to that, Judge.
And that would be my understanding as well. Ms. Swallow?
Yes, Judge.
Ms. Fuller?
Yeah, it's just in regards to the child support, the amount to be set, and then Mr. Sanchez has a previous order, so when it's dismissed, it just goes back to his previous SAPS or order.
Okay. Ms. Ituarte, you heard the agreement? You need to unmute, ma'am.
Yes, sir.
All right, is that the agreement you made?
Yes, sir.
Right. Did you enter into it voluntarily?
Yes, sir.
Did you have a chance to discuss it with your attorney?
Yes, sir.
Were you forced in any way to go agree to it?
No, sir.
Are you asking the court to approve it today?
Yes, sir.
Okay. Mr. Rodriguez, same questions for you. Is this the agreement as you understand it?
Yes, sir.
Do you have the opportunity to discuss it with your attorney?
Yes, sir.
Do you understand what's expected of you?
Yes, sir, I do.
All right. And did you enter into this voluntarily?
Yes, sir.
Were you forced in any way to agree to it?
No, sir.
Are you asking the court to approve it today?
Yes, sir.
All right. Mr. Sanchez, same questions. Is this the agreement you made?
Yes, sir.
And this is requesting a dismissal of your case and reverting back to the prior order. Do you understand what that means?
Yes, sir.
All right. Did you have a chance to discuss this with Mr. Saldivar?
Yes, sir.
Okay. All right. And I think you said, Ms. Acevedo, that he didn't sign it, correct?
That's correct, Judge.
Okay, we'll stop there. Okay. Then, having heard the announcements of the parties as it pertains to the parties mediated settlement agreement, having admitted it as an exhibit in this case and reviewed it myself, court does find that the agreement of the parties is in the best interest of the children, and the court will adopt and approve the agreement. One more question I had for Ms. Gentryman. Ms. Gentryman, you believe the dismissal of Zaley's case in this matter is in the best interest of the child?
Yes, Your Honor, I do.
Okay, and you believe that reverting to that other order and getting that child out of this particular case addresses the concerns and relieves the department and belong of any further duty to providing for this child?
Yes, sir.
Okay. Then at this time, I think it would be appropriate to enter the MSA as an order of the court and to dismiss Zaley's case out through the severance that the parties have agreed to. By severing that case, that would therefore dismiss Mr. Sanchez from this case, as well as Mr. Saldivar, and in this case of this hearing right now, Ms. Acevedo, and allow us to proceed with the testimony as to child support and the argument on the name change as to Mr. Rodriguez and Missy Duarte. Does anybody see any issue with that?
Except I would, if possible, I'd like to propose, I've got 5 other exhibits for this case that I would like to have admitted.
Okay, you want them admitted prior to the severance?
I just don't want it forgotten. No, after the severance.
Okay. All right. Then the court will order the severance of the causes and sever out the child Zaley and Mr. Sanchez, and whatever orders are in place at this time as to that child between Missy Duarte and Mr. Sanchez, those orders control from this point forward. I will also dismiss Mr. Saldivar at this time, which excuses Ms. Acevedo from this hearing. So at this time, Ms. Acevedo, you are excused.
Thank
And
you.
Mr. Sanchez, you are excused. Good luck to you, sir.
Thank you.
You're welcome.
And Your Honor, I haven't seen any of the exhibits. I mean, obviously I was a part of the MSA, but did we get the exhibits?
I think that I had sent them out prior, quite a while ago prior to the extension in this case, but I don't recall if the parties did. It's the CCJ letter, it's the paternity registry search, and it's the service.
But we have a father that's been adjudicated.
I don't recall if I have the order adjudicating, but this was just to ensure the procedural and jurisdiction was correct. I don't, if there's no objection, I don't have to go through the motions of this, but
Mr. Rodriguez has been adjudicated. So the paternity registry search, is all of that necessary? I don't think so. We're not seeking to terminate an alleged father.
No, but I don't see an order adjudicating, so it might have been embedded in another order.
Well, I mean, we can adjudicate him. I mean, he is her father. And I'm pretty sure I'll look through everything I have, but
Why don't we look at what exhibits Miss Kyler Green has? You can screen share them, and we'll go through each one and determine whether or not we need to admit it or it's relevant. So Miss Kyler Green, why don't you just start wherever you want to start? Tell me the number, and we'll go through them one by one.
So your Honor, Exhibit 1 is the citation for Alexis E. Duarte. Exhibit 2 is waiver of service for Michael Rodriguez. Exhibit 3 is the CCJ letter for Mayeli.
No objection.
Section.
Exhibit 4 is the paternity registry search. This was just done before we had the adjudication of parentage, of paternity, excuse me. And exhibit 5 is the prior MSA.
Judge, I don't see the relevance of exhibit 3 and 4.
Well, 3 is relevant because it shows that there was no previous jurisdiction for this child, whether it was with Mr. Rodriguez or with someone else. So I think 3 is relevant. 4, I mean, as long as he's been adjudicated, I don't know if that matters, but-
It's redundant, Your Honor. I'm just trying to cross all T's and dot all I's, but it's not really worth the time.
Well, I believe that I agree with Ms. Fuller. I think 3 is relevant enough to admit. 4, I mean, I could admit it, but the thing is, he has not been adjudicated yet, correct?
Well, that's the question. I've got to look through everything, my entire file right now. I believe that he was judged, so now I've got to find the order.
I'm going to look through my notes as well. Let's just take a moment and do that.
It's here, Your Honor. It was just in the wrong file. It was signed on the 21st day of October. That's my fault.
So he was adjudicated.
Yes, Your Honor.
Okay.
It was filed on October 21st.
Then that takes care of that. What would you say? What did you say petitioner's 5 was, or was there a 5?
There was a 5. It was the prior MSA in this case, Your Honor.
Why do we need that?
It was just to kind of establish a lineage of this case. It's if there's any objection to it, again, I don't know if it's worth the court's time to litigate it, but
I'm pretty sure I'm going to object to relevance. We have this agreement that disposes of the case, and I imagine that was already entered.
Well, if this court has already signed an adjudication, then I don't see the relevance of P4. So court will not admit P4. And if the current mediated settlement agreement controls over any prior mediated settlement agreement, then I don't see the relevance of P5. So neither P4 nor P5 were admitted. And do you have any other exhibits at all, Ms. Kyler Green, or is that it?
That's it.
Okay, then that takes care of that.
And Judge, if I may address the notice issue when the court is ready.
Well, let's get through the testimony on guideline child support. Since we need to have a specific enforceable order, I want to make sure we leave here today with those numbers. So, Ms. Acosta, did you say you were going to handle that testimony?
I can, Your Honor. And with permission, I'd like to keep my camera off. My internet's been going in and out, so I'm hoping this helps.
That's fine, no problem. Thank you. All right, you may proceed.
Okay. I'd like to call Mr. Michael Rodriguez. Mr. Rodriguez, how are you related to this case?
I'm Mayeli's father.
Okay. And are you currently employed?
Yes, ma'am.
Where are you employed?
The Hondo Beer Market.
And how many hours a week do you work?
It's just Friday and Saturday, so I'd say about probably 15.
Are you able to work Monday through Friday?
Once this is over, yes, I'll be able to.
How much do you make per hour?
I get 100 a night.
Are you working per night?
What's that?
How many hours are you working per night?
I'm not even too sure. Just whenever they call me in. It's just Friday and Saturday, so it's $200 a week.
Well, generally speaking, from what time to what time do you work on Friday?
On Friday, 8 to 2 or 8 to 3.
So 8 in the evening until 3 in the morning?
Yes. Same thing on Saturday.
And you said once this is over, you'll be able to work more?
Yes, ma'am.
Okay, why are you not working more right now?
Because I would have to stop. I would have to not miss work, but I would have to work around going to NA meetings and doing therapy and doing parenting. And most jobs they don't really care what I got going on. You know what I mean? They don't have to put up with that or whatever.
Do your NA meetings or your counseling occur from 8 p.m. to 3 a.m.?
Judge, objection to relevance. He already stated that he's going to be making more money in the future. So I'm not quite sure where Ms. Acosta is going with this.
Your Honor, it's relevant because he stated that he isn't working right now because of his services. Services don't occur 8 p.m. to 3 a.m. So I'm trying to argue that he's intentionally underemploying himself so as not to have to pay child support at the amount that he should be paying right now.
Judge, that is not that there are no orders right now for him to pay child support for whatever this court orders today. It was not, we're not litigating the past. We're talking about this moment in time right now. And he just testified that he's going to be making more money in the future.
And Your Honor, I'm in agreement with Ms. Acosta. I don't understand why. I think this is relevant. The fact that he's saying he worked 2 days a week. He wasn't even participating fully in his services to begin with. So I don't know why that would have stopped him from working full time to be able to provide for his daughter. He's known this is his daughter and hasn't provided for her since she was born. And so, I mean, I think we need to get a real good picture of what he's capable of doing and working and making, and not $200 a weekend.
I agree.
Regardless,
the
I pay child
MSA,
support.
hang on, sir. The MSA is for guideline child support. I need to know what he's making. I need more information to know what is guideline child support according to his wages. So I'm going to allow the testimony overruled. You may continue, Ms. Acosta.
Thank you. Mr. Rodriguez, where did you work prior to the beer market?
Little Caesar's Pizza.
And how many hours a week did you work there?
It was just a part-time job, and I was only making $8.50 an hour.
And to be clear, right now you're making $100 a night, correct?
Yes, ma'am.
And you said that after this case is complete, you'll be able to work Monday through Friday as well?
Yeah.
So arguably you could make $100 a day at least. Is that correct?
I wouldn't say that much, but I already pay. I have 2 older kids that child support will be getting taken out of for my check as well. So,
will you continue working at the Hondo Beer Market?
Will I?
Yes. Is your plan to continue working at the Hondo Beer Market?
Unless I can find a full-time job where I don't need to, then I won't.
Have you ever had a full-time job in the past?
Yes, well, not since I've gotten out of incarceration.
Okay, and prior to incarceration, what was your full-time job?
Oh man, I was not working before that. I was messed up on drugs.
So you testified previously that you did have a full-time job previously, correct?
I said I worked at Little Caesars part-time.
Prior to incarceration, did you work?
No.
Okay, I'll ask the witness, Judge.
Ms. Skylar Green.
No question, John.
Ms. Swallow.
Thank you. Mr. Rodriguez, are you willing to pay minimum wage guideline child support for your daughter, Mayeli, with consideration of your other 2 kids that you also pay for?
Oh yeah, of course.
Okay. Thank you. Pass the witness.
So there's a support order not before this court for 2 other children.
That is what I understand from his testimony.
Okay. But nobody's seen it?
I have not seen it.
Okay, go ahead, Ms. Fuller.
Mr. Rodriguez, when's the last time you paid child support for the other children?
It comes out of my checks when I was at Little Caesars as a medical support, so I'm assuming it's for child support, right?
So the medical support, so they take out $50 out of your
100.
check? 100.
100.
Okay. And do you know what that when you were ordered to pay that child support?
No, I don't remember.
Okay. And so if those 2 children are taken into consideration, then your child support would be reduced. It would not be 20%. I think it would be 16.5% based on having 3 children. Are you willing to pay that for your child?
If I have to, yes, of course.
Are you willing to pay any back child support from the time you were adjudicated as the father?
Judge, that's not what we're asking for
I'm
today.
asking a question, Your Honor. That's for him to answer. She didn't object.
Objection. Relevance to why we're here right now talking about this for future child support, not back child support.
I'll over or sustain the objection, Ms. Fuller. We're talking about guidelines, so if there's an arrearage action, it's not pled today, so I'll sustain.
Can I get the name of the person that's with Mr. Rodriguez? I heard you say yeah.
Who's there with you, Mr. Rodriguez?
Oh, my mom.
Okay, what is her name?
Judy Perez.
Judy Perez. Okay, you may continue, Ms. Fuller.
I have no further
Sorry, Ms.
questions.
Fuller.
I have no further questions.
Okay. Based on what I've heard so far, does anybody have any follow-up?
I have a couple of follow-up questions, Your Honor.
Go ahead, Mr. Costa. You can go ahead.
Mr. Rodriguez, do you currently pay rent anywhere?
Pay rent, light, internet. Me and my girlfriend, yes.
And how much is your rent?
$900 a month.
Okay, and do you pay for all of that?
I just said yes, me and my girlfriend.
I'll pass the witness, Judge.
Okay. Any other evidence that we need to hear today as far as these orders go?
Judge, I would like to address the name change.
All right.
Can I just ask Mr. Rodriguez one more question? I'm sorry, Your Honor.
No, it's
Mr.
okay. We've got time.
Mr. Rodriguez, you're fully capable of working a full-time job, correct?
I wouldn't see why not. Yes, ma'am, I am.
You have no medical issues or any kind of mental health issues that would inhibit your ability to work full-time.
Perfectly healthy.
Okay. And so you should be able to work at a minimum of 40 hours a week to provide for your child.
My children, yes.
Well, we're here for my Ellie. So you're willing to do that?
Of course.
Pass the witness.
Okay, let's take up the issue of this motion for name change that was filed. Ms. Fuller's arguing it's not timely notice. Ms. Swallow, you're arguing that it is.
Judge, I filed it last Thursday. Unless I'm having complete like senior moment at my not quite senior age, I believe that that is timely.
Well, it's usually 3 days, not counting the date of the hearing. So Friday, Saturday, Sunday, Monday. I mean, I don't think the weekend is excluded.
So then,
I think it is. But
Your
Honor. All our judicial economy. So is he supposed to go back, open a new case, file for a name change? This is his daughter. He's requesting that his name and the mother's name be included in her last name. It's in the best interest of the child to have her father's name too.
And we had a mediation.
One at a time. One at a time.
Thank you. I don't understand what the bias is against him. This is his daughter.
There's no bias, Your Honor, against him. My understanding is the rule is the business days, so it will be 3 business days for the motion. Not the weekend is not included on the motion. And so if the parents want to agree to something, I have no problem with that. We were at a mediation that lasted over 5 hours. It never came up. So if they want to agree to something, I don't have a problem. But it was never even brought up.
That was my fault. That was my fault.
Never brought up. And with regard to the notice issue, I believe that if it's less than that, the notice has to be 5 days, depending on if there's a weekend in between there.
5 days, Judge, then I'm requesting a reset.
If they have an agreement, just put the agreement on. Like I said, we never heard anything about it.
And Your Honor.
Hang on, one at a time.
He's tried to confer on the issue. He sent her the exact name he was proposing, which is the exact name in the order. It includes both of their names. It just adds his name, which biologically she is his child, which we know. I'd like to hear why this would not be in her best interest to have her father's name too.
All right, the rule is under TRCP 4. Ms. Acosta is correct. Saturdays and Sundays and legal holidays shall not be counted for any purpose in any time period of 5 days or less. except that Saturdays, Sundays, and legal holidays shall be counted for purposes of the 3-day period in Rule 21 and 21A, extending other periods by 3 days when service is made by mail. Everybody good and confused now?
Well, it sounds like then I'm fine, but I would argue still that this is not, this is in the best interest of the child. It's not some crazy surprise. It's in the child's best interest. I haven't heard any argument to say that including this child's father's name in her name, which is her name, is not in her best interest.
I'll get to that in just a moment.
And Your Honor.
Hang on just a second. I was an English major. Math is not my strong point, so I got to think about it really hard. I think based on what I'm reading in 4 and 21B, 21B says an application to the court for an order or notice of any hearing thereon not presented during a hearing or trial must be served upon all other parties not less than 3 days before the time specified by the hearing. And 4 says, the end of 4 says, Saturdays, Sundays, and legal holidays shall be counted for the purpose of 3-day periods in Rules 21 and 21A. I think she's okay on her notice.
And I'm a senior, so I had a senior moment because I thought it was the weekends were not included.
Well,
I feel it's in her best interest to have his last name. That's not the issue. I thought the rule was you had to have 3 days notice. I just wanted the rules to be followed. That's all.
No, and I'm glad you did because it's hard to remember those nuances, and I think that rule was changed a little bit. So the reason we have these books that are so readily accessible to us during these proceedings is so that we can check ourselves, because it's impossible to remember all of these details of every rule we have. So there's no apology necessary. All right, then.
And Your Honor,
The notice issue isn't a problem. Let's just hear whatever response you have to that, Ms. Acosta.
Your Honor, I haven't discussed this with my client. I was sick Friday, Saturday, and Sunday, and it didn't come up at mediation. So if I had a breakout room with her, it might resolve the issue of what her position is. But the first I heard of it was when I saw the motion, and I haven't spoken to Ms. Ituarte about it.
And Judge, I can simply call her as a witness.
I'm going to give them a minute to talk about it. We've got time. Just 1 minute, though, Ms. Acosta. You're in room 1.
Thank you, Judge.
Let's take a brief recess. Everybody take a deep breath. We'll take a quick recess, and we'll come back. All right. Do you have any objection or any testimony you want to elicit, Ms. Acosta?
Your Honor, my client.
Can't tell if she's breaking up or thinking.
I apologize, Judge. I'm not sure what's going on with it. Can you hear me?
I can hear you. Just you break up every now and then.
Okay. I think I'm having a clear moment. So let me, let
me see if I can simplify this. Does your client object to the name change?
Yes. She
Okay.
does.
All right. So then what I would like some testimony from, I guess, your client as to why. But I don't know that you're going to be able to elicit it with your issues on your end. So, Ms. Swallow, would you like to question Ms. Ituarte on the name change?
Yes, Judge.
Okay, go ahead.
Do you understand that I represent Mr. Michael Rodriguez?
Yes.
And did he reach out to you last week to discuss including his name and Mayeli's name?
I'm sure he tried, yes.
Okay. Did you respond?
Yes and no.
Okay. Can you he proposed the name Mayeli, is that correct?
Yes.
Okay. And your testimony today is that you do not think that her name should be changed to include her biological father's name?
Yes and no.
It's a yes or no answer.
Mm, yeah, that's fine.
Thank you. I pass the witness.
Any other questions?
No, Your Honor.
No, Your Honor.
All right, and Miss Swallow, I just want to make sure I understand. Proposal is Maeli.
Yes, Judge.
Okay. Submit an order with that name change, the court will grant it. And just for the purposes of the record, there's no other reason for the name change. This is solely just to have her biological father's last name.
Yes, Judge.
All right. And you believe that, Miss Gentryman, do you believe the name change is in the best interest of the child?
Yes, sir.
Okay. All right. It's granted. Then the court will, I'd like to hear argument now on the child support amount. I heard testimony, but I don't think I ever heard argument.
Your Honor, if you're gonna start with the department, we don't have a position. The besides what is stipulated in the MSA that we agreed to, whatever
Okay.
his determined guideline, whatever his determined amount is for guidelines.
All right. Then I will allow Ms. Swallow to begin argument.
Thank you, Judge. I would request that he be ordered to pay minimum wage guideline support for Maeli with consideration of the other two children he testified to that he pays on. So whatever that amount is. And he says he makes, about $800 a month. However, he says he has the potential to make more. So I would request that in order to meet in the middle and satisfy his capability, his earning potential, that it be based upon not the low income multiple family, but the multiple family adjusted guidelines. So that would be, I think, 16%.
And you're saying 16% of the monthly wage resource of $1,256.67?
Yes.
Okay. Argument, Ms. Acosta?
Yes, Your Honor. Mr. Rodriguez testified that he makes $100 per night on Fridays and Saturdays, and that he's able to work 7 days a week. However, he doesn't. So I would request that his child support be calculated based on him making at least $100 per day. He isn't working, he says, because of the services that he was participating in. However, he's working in the evenings when services don't occur. So I would argue that he's capable of making $100 a day. He's just not.
And Judge, we don't know for certain that this job is available for him Monday through Friday at $100 a day. So I think the fair way to go would be what I have proposed.
Your Honor, I feel that Mr. Rodriguez hasn't intentionally underemployed himself, working 2 days a week. He didn't participate in the services fully, and he worked 2 days a week. He had 5 other days. I would agree with Ms. Acosta that if he can make $100 a day, we should base it on $100 a day. I don't think it's fair to this child for him not to provide for her, and him working 2 days a week for, less than 8 hours a day, so 16 hours a week, it's not sufficient. He testified he was fully capable of working. He won't be engaging in these services anymore. So there's no excuse for him not to be able to work and fully provide for this child.
And Judge,
so I don't think Ms. Swallow's argument is justified in this case. Unfortunately, we don't have good numbers. We don't even know if $100 a night is accurate. We've never been provided anything to show what he makes.
And Your Honor, just briefly, what he's making right now is roughly $16.66 per hour. So I would request that it be based off of that and not off of minimum wage.
It's about $100 difference if I order minimum wage, child support at 16%, or order that he is making he's capable of making $100 a day for 5 days a week at 16%. The first one is $182.31. That would be the child support amount for minimum wage, child support at 16% of his net monthly resources. And then if we did it for 5 days a week, $100 a day, that's net monthly resources of $1,829.43 times 16% is $292.70.
And Judge, if I may, I'm requesting that this court not order him to pay on a job for which he does not have. We're assuming and speculating that he can make and secure a job at $100 a day.
Well, what we're looking at really is he underemploying himself? And I haven't heard enough evidence here today to satisfy the statute that he has indeed unemployed himself. He did testify that he was incarcerated. He's been in a CPS case. Do I think that he's capable of making more money? Yes. But do I think that he's been capable of making more money up to this point? I don't know. I didn't hear enough evidence. So I'm going to order minimum wage child support in the amount of $182.31 and find that that's in the best interest of the child. Court finds there's not enough evidence to allow the court to deviate from the guidelines in this case. And Mr. Rodriguez is to pay that amount pursuant to the mediated settlement agreement, and the dates that it's supposed to start and then be recurring thereafter. So that takes care of the child support issue.
Your Honor, what was the specific amount? 182 and how many cents?
It's $182.31 is the exact amount that I came up with for guideline child support at minimum wage at 16%. So if you all want to round it, that's fine, but that's the exact amount that I got. He's also ordered to pay $25 cash medical support the first of each month, or the 1st of January and the 1st of each month thereafter, unless your MSA set a different time period, but I think that's what it was. Guideline child support at $182.31 to begin January 1st, and then they're payable on the 1st of every month thereafter. And then, the court will name Mr. Duarte as the sole managing conservator of the child, Miley. Court will name Mr. Rodriguez as the possessory conservator of the child, Miley. Order the parties to adhere to the visitation schedule and the mediated settlement agreement that was read into this record and should be attached to the order when it's prepared. The court will order the parties to split any uninsured medical expenses 50-50. And all the attorneys ad litem and the department are dismissed. In their representation, the court will find that the attorneys have satisfactorily performed their duties. And there will be no further hearings on this matter. Anything I failed to address?
No, Judge, I would request that the dismissal be upon entry of the orders, because we're going to have to get through drafting and getting those out. And I would also request, if we have the new cause number, that be shared so that I can draft the name change order.
And I will clarify for the purposes of the record and the purposes of the orders that the orders I'm making today are pending entry. that the severance order needs to be sent to me. I think it already was. I just need to sign it. It needs a cause number. And then the other orders need to be prepared, reviewed, and signed, and filed in the due order of pleadings. With that, is there anything I failed to address?
No, sir.
All right. Well, thank you all for your hard work on this case. I saw the mediation report, saw the bills. I know you all worked really hard, and I appreciate everybody putting so much time into it. And I wish the family good luck. And thank you all for your time and your service. And if there's nothing further, all parties are excused.
No objection.
Thank you.
No objection.
I'll see some of you after lunch. Ms. Collard Green, with that, would you please begin the announcements?
Yes, Shauna, good afternoon. Emily Kyler Green, attorney for the department.
Catherine Shove, permanency specialist for Belong.
Christy Cannot, permanency supervisor with Belong.
Jennifer Harris, attorney for respondent father, Mr. Alaquinos. I've had no contact. He's not present. I'm announcing not ready, Your Honor.
Rochelle Acevedo for the mother, Marisol Reyes. She's present. Ms. Reyes, will you please announce?
Marisol Reyes. Alana Pearsall, attorney for intervener Janelle Peralta, who's present, and I'm ready. Ms. Peralta, will you please introduce yourself?
Hi, Janelle Peralta.
Deborah Fuller, attorney and guardian ad litem for the child. Ready?
Jill Roden, Tri-County CASA.
Kristen Rumley, CASA volunteer.
Ms. Harris has announced not ready due to no contact with her client. Mr. Alaquines is aware of these proceedings and signed a waiver of service back in September. So the court will overrule that not ready. We will proceed. Ms. Shelf, I was able to review your report. Looks like permanency goal as of the time you filed your report was still family reunification. Is that still the case?
Yes, sir.
Okay. And is the placement of the child with Ms. Peralta still safe and appropriate?
Yes, sir.
Needs?
Yes, sir.
All right. And is this in the best interest of the child to remain there?
Yes, sir.
And is this the least restrictive placement possible?
Yes, sir.
And Raina's up to date on her medical, dental, and vision?
Yes, sir.
Any developmental concerns?
No, sir. I'm sorry, Judge. She does have the abnormalities in her gait due to her bones not being completely equal, but she was evaluated by an orthopedic doctor, and they are not wanting, they just stated to monitor, no future actions moving forward.
Okay, thank you. She's not receiving any medications at this time?
Correct.
You feel as if all her needs are being met?
Yes, sir.
She bonded to the placement?
Yes, sir.
Is Raina having contact with either parent at this time?
She does have visitation with Miss Marisol Reyes.
And how does that visitation go?
The visitation goes very well. She does have visitation every other week for the duration of 1 hour. We usually do it at Burger King or the park. Visits are always very happy. Rain is happy to see Marisol, and Marisol does address her needs during the visit.
Is Ms. Reyes in compliance with her family plan of service?
No, sir.
Why is she out of compliance? What does she need to do?
She does need to enter inpatient treatment. She does need to get going with her individual counseling and begin those sessions. She needs to complete a psychological evaluation. She needs to engage in parenting classes. She has recently started her domestic violence classes. She did attend one class 2 weeks ago, and then she did miss last week. And then she did complete her anger management class.
What about Mr. Alaquinas?
He is not in compliance.
What does he need to do in order to be in compliance?
He needs to submit to DNA paternity testing, sign a release of confidential information, and engage in random drug testing to follow a drug and alcohol assessment if positive, complete domestic violence classes, complete a psychological evaluation, follow the recommendations, individual counseling, and parent-child visits, and parenting classes.
So essentially everything.
Yes, sir.
So neither parent is in compliance at this time.
Correct.
Do they both have copies of their family plan of service?
Yes, sir.
Have you discussed it with both of them?
Yes, sir.
When was the last time you spoke with Mr. Alaquinas?
On September 6th.
Does Ms. Reyes stay in touch with you?
Yes, she does.
Is that primarily in regard to visitation, or does she maintain any contact with you regarding her service plan?
Originally, it was primarily visitation, but as of recent, she has stayed in contact with me regarding services.
As of today, is it safe to return the child to either parent?
No, sir.
As of today, has either parent addressed the concerns that brought Raina into the care below?
No, sir.
Ms. Carla Green, do you have any questions?
Yes, Your Honor, thank you. Is Ms. Reyes engaging in random drug testing?
She is.
Okay, and have you gotten the results back from those?
Yes, ma'am.
Are there still concerns about her drug use?
Yes, ma'am.
Have you point blank discussed with her the need for inpatient treatment?
Yes, ma'am.
Okay, and do you have any idea what the hesitation is?
She stated she did not want to go due to concerns of not being able to see Raina while she was at the inpatient.
Okay, were you able to discuss the possibility of her still exercising some form of visitation with Raina if she were to go to inpatient?
Yes, ma'am.
Okay, and did that not assuage her fears?
At that time, no. As of recent, she has contacted me on Friday and today and stated she is wanting to go to inpatient, and I have given her the options of Journey Recovery and Alpha Home.
Okay, are those two facilities ready, willing, and able to take her?
She has an active referral to Journey Recovery. She just needs to call to confirm the bed available. Alpha Home was ready and willing to take her in October. All she would need to call and confirm if they still have availability.
Do you know if she has the number for these places?
She does.
Okay. Do you know if she's called yet?
I do not know.
Has she asked for any help?
We spoke about it a little bit this morning, and I've responded to her by text message. I have not spoken to her since then.
Okay. The fact that she took one domestic violence class and then did you testify that she didn't take the second one this week?
It was last week.
Last week she did take the test, or excuse me, she did take the class?
I'm sorry. 2 weeks ago, she did go to the class, and then she missed last week.
Okay, and is she supposed to go back this week?
Yes, ma'am.
Okay, why is it concerning that she's already missed one class?
The lack of consistency.
Okay. Were you able to speak with her about the one class that she did take?
Yes, ma'am.
And did she give any feedback on it and her willingness to continue it?
No, ma'am. Her concern was due to the distance to the facility.
And you said that she did complete anger management. Was that virtual or in person?
It was virtual.
Have you been able to assess where Marisol is living?
No, ma'am.
Have you asked?
Yes, ma'am.
Okay, and what is the response when you ask to assess the home to see if it's safe for Raina?
She does state she is currently residing with her grandmother. I did go by there, but nobody was home.
Will you try again?
Yes, ma'am.
Did you let her know you were coming by?
No, ma'am.
Are there any changes to the family plan of service since either parent were last given a copy?
No, ma'am.
Okay, Your Honor, that's all I have. Thank you.
Ms. Acevedo?
Thank you, Judge. With regard to the actual services, are all of the 2054 still active?
Yes, ma'am.
Okay. What services will she get at either Journey Recovery or Alpha Home?
She'll be able to complete the inpatient for substance abuse.
Do they also offer like either the domestic violence, the counseling, anything else, parenting?
I do know they offer counseling. I will have to confirm on the others.
Okay. And I guess the concern, what is the department's recommendation right now if her plan is to go into inpatient? and I'll word that another way, I'm sorry. Does the department want her to start these services, or is priority getting her into an inpatient?
The priority is to get her into inpatient.
Okay, because assuming she starts these with a counselor and this anything else, she'll have to stop, correct?
Correct.
Okay, and I understand the onus is on her, but have you called Journey or Alpha Home to verify whether there's a bed available?
I spoke with them previously. I have not spoken to them as of recent.
Okay, and do you know if she's called to verify whether there's a bed available?
To my understanding, I do not believe she's called them specifically.
Okay. And how does that work? Do they need a 2054, or is that just something she calls and if a bed's available, she gets to go in?
With Journey Recovery, she has an active referral through OSAR, which I confirmed is still active this morning when I spoke with OSAR. Alpha Home, because I've already spoken to them, she just has to call them and they'll be able to get her going as long as they have the availability.
Okay, and I think that's something I want to clarify. She did take a UA, correct? She did a UA and a hair follicle?
Yes, ma'am.
Okay, now was her UA clean?
Yes, ma'am.
Okay, and did you expect her hair follicle to be dirty?
Yes, ma'am.
Okay, considering she had the clean UA, will these providers still accept her?
Yes, ma'am.
Okay. Is it normal that they ask for a dirty UA within the last 30 days?
Not to my knowledge or my understanding when I spoke with Alpha Home.
Okay. And then with regard to the domestic violence, where is she taking it?
Family Violence Prevention Services.
And that's in San Antonio, correct?
Yes, ma'am.
Do they offer virtual?
That program does not, no, ma'am.
Okay. Is there anything either closer or that provides virtual that that you can recommend?
I had tried doing her through Safer Path, but they are no longer accepting her as a client.
Okay. And who's her therapist?
Her therapist will be through Optimal Counseling.
Okay, so she hasn't been assigned.
Correct.
Okay, and then she has all of the contact information for these same providers.
Yes, ma'am.
Okay. And the department is still willing to work with her.
Yes, ma'am.
I'll pass, Judge.
Sam, when is the last time that you had contact with Mr. Alajinas?
On September 6th.
And what attempts have you made since then to get in contact with him?
I have called and texted him. I've gone by the home numerous times that he told me where he was residing. I have spoken with his mother. I have also done searches through VineLink, White Pages, trying to reach him.
And have you checked with any hospitals or jails?
I have checked with the jails, not with hospitals.
Okay. Was there some concern about his health previously?
Yes, ma'am.
Have you received any indication that he may be hospitalized again?
No, ma'am. From my understanding, when I spoke with his mother last Friday, he's not in the hospital.
When you spoke with him, were you able to explain what his service plan was and what was expected of him?
Yes, ma'am.
Was there anything about his health or his mental capabilities that made it impossible for him to complete those services?
No, ma'am.
Did you make sure that he was aware he had an attorney?
Yes, ma'am.
No further questions, Judge.
Pearsall.
Thank you, Honor. Mother's order recommended that she go inpatient, correct?
Yes, ma'am.
Okay. And then subsequently, the court ordered her to go inpatient on August 25th. Is that correct?
Yes, ma'am.
And she hasn't gone inpatient despite the other assessment or the court order. Is that accurate?
Yes, ma'am.
On October 12th, mother actually got a bed at Alpha Home. Is that accurate?
It was offered to her. Yes, ma'am.
And did she know it was offered to her?
Yes, ma'am.
And what was her response?
She stated she did not want to go.
Did mother submit to hair follicle on August 7th of this year?
Yes, ma'am.
And what was the result of that hair follicle?
It was positive for amphetamine and methamphetamine.
Did mother submit to UA on September 22nd of this year?
Yes, ma'am.
And what was the result of that UA?
And positive for amphetamine and methamphetamine.
Did she submit to a hair follicle on November 30th of this year?
Yes, ma'am.
What was the result of that?
Positive for amphetamine and methamphetamine.
And why hasn't her counselor been assigned as of yet at Optimum Counsel?
I have a call out to them to confirm if they have heard directly from her. I have not heard back as of yet.
Okay. But generally speaking, a counselor doesn't get assigned until a person reaches out and asks for her first appointment, correct?
Correct, once communication has been established.
No other questions.
Ms. Fuller?
In regards to Ms. Reyes' services, do you feel like she completely understands what she needs to do in this case?
Yes, ma'am.
And you've offered her all the advice in regards to contacting inpatient and domestic violence and counseling services?
Yes, ma'am.
Do you think you could have done anything different to explain to her how important these services are?
No, ma'am.
And the hair follicle in November 30th, was that in fact, you said it was positive for methamphetamines. That was at a level of like 47,000, correct?
I would have to pull up the levels. I don't recall specific.
It was extremely high level.
Yes, ma'am.
And so even though she had a negative UA, any inpatient treatment program would accept her based on this extremely high level on her hair follicle.
Yes, ma'am.
And so although she talked to you this morning, has she continuously told you that she was not going to inpatient?
Yes, ma'am.
And so I know we're at the 6-month mark and I know the plan's family unification, but do you think that's appropriate in regards to Ms. Reyes because of her total non-acceptance of the services that the department can provide or Belong can provide?
Currently, I do due to the fact there's still time.
Okay. And do you think there's anything you can do differently to assist her?
I do not.
But you don't know where she's living.
I'm so sorry to interrupt. Ms. Acevedo is in the waiting room, and she's asking to be let in.
No. So you have no idea where she lives?
I have not been able to confirm it, correct.
Do you know she's employed?
She's not employed.
Okay. And so, I mean, and she hasn't really done any of her services except the anger management, correct?
Correct.
And since she completed the anger management, did she have an incident where she ended up with stitches and she was cut in an argument?
Yes, ma'am. She stated it wasn't an argument, but that she did get angry and hurt herself. Yes, ma'am.
And that was after she completed the anger management, correct?
Yes, ma'am.
So do you think that virtual classes are effective for Ms. Reyes?
No, ma'am. Not for the anger management.
Okay. I'll pass the witness, Your Honor.
Just one question, Your Honor. How did Ms. Reyes hurt herself?
She stated that she had put her arm, I'm not quite sure whether it was hitting against a window or through a window when she got angry.
Thank you. Nothing further, Your Honor.
Any other witnesses? Anybody else have any other witnesses?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Well, the court did hear a lot of evidence last week on the 5th, but I did review the report that I got. Anything you want to add, Ms. Fuller?
I'm just really concerned. I mean, she is very good with her daughter. Her daughter does have a connection with her and loves her, but we're not getting anywhere with the services, with her drug use. I mean, it's still excessive drug use. And I mean, I don't know what more can be done. I mean, you've ordered her into inpatient. The department has tried to assist her with everything. And this child will need permanency. And I'm just concerned that Ms. Reyes isn't going to be able to do that because she is not willing to engage in the services. And it is sad because this child does have a connection. She is bonded to her mother. I've seen her in the visits. I have not had any concerns about the visits, but you have to have a place to live. You have to be clean and sober. You have to be able to take care of your child. And so that's my concern, Your Honor.
Thank you. Dr. Rumley?
Sobriety is very, very hard. And so I have a similar concern as Ms. Fuller because even if she went in now and did all these services, relapse does happen. Sobriety does not always happen so black and white where you start treatment and you stay sober. And so I'm also concerned about the timeline. I agree with Ms. Fuller. I would love to see her get clean and sober and be a healthy mom for Raina. I'm just concerned with the current timeline and being able to actually not only complete treatment, but stay sober and do it in a linear form, which is just really, really rare, especially with the type of drug that she's using. I just have similar concerns.
Thank you. For the purposes of the initial permanency hearing, court finds that permanency goal at this time, halfway through the case, remains family reunification. Fine at this time if that's appropriate. I'll address that more in a moment. Court finds that the placement for Raina with Ms. Peralta is safe and appropriate, meeting her needs and in her best interest to continue at this time. And that this is the least restricted placement possible. The court finds that Raina is up to date on her medical, dental, and vision, and that her gait abnormalities are being evaluated. She's not receiving any medications at this time. Court finds that she is bonded to her caregiver. I'll continue the visits at this time, but I'm going to address that here in a moment as well, since they are appropriate and the child is enjoying them. But we need to talk about that. I'm going to find that neither parent are in compliance with their family plan of service at this time. Both of them have quite a long list of things to do at this point, halfway through the case. Going to find that both parents have copies of their family plan of service and that Ms. Schoaf has discussed those family plans with them. As of today, it's not safe to return the child to either parent, and neither parent has fully addressed the concerns that brought the child into the care of Belong. I'll find that the department is making, or Belong is making, all reasonable efforts necessary to achieve the permanency goal, and that Ms. Schoaf has made multiple efforts to work with Ms. Reyes and reach out to Mr. Alaquinez, Center for Drug Testing, provide her with 2054s, and unfortunately, they're not following up. All right, Ms. Reyes, I want you to listen to me. I know that there's a lot of people talking to you, and that I've made decisions in this case that you didn't like, but I really want you to listen to me. You have a chance here to turn your life around. And you have a chance to, in my opinion, save your life. You've tested positive for methamphetamines and amphetamines for the last 3 months. That's going nowhere. I'm sure you've heard people say that before, and you're probably tired of hearing it. You are a nice person. You have sat in the courtroom in front of me and listened to me say things that would be very upsetting to most people, and you've taken it all in stride. I can see that you're a nice person. I can see and hear that you're a great mother to your daughter. The worst thing that can happen in this case is for you to not get help with your drug problem. Whatever happens at the end of the case, I think I speak for everybody in this room when we all say we want you to get clean. Do you understand that? We want you to be healthy. We want you to be happy, and we want you to be a part of your daughter's life. Whether you feel that coming from us or not, that's what we all want. That's why we do what we do. But if you don't do these things that you're supposed to do, if you don't go to inpatient, you're not going to get there. And you're going to look back in another 6 months or a year, and you're going to say, I wish I had done it. And not getting to see your daughter because you're an inpatient is not a reason to not go. We'll figure that out. But you've got to get there. I'm going to order you back, and I'm hoping that you go. And I hope you don't see it as a punishment. I hope you see it as a way out, because that's what it is. Do you understand what I'm saying? You can do it. You can change your life. You can get out of this. Okay?
Yes, sir.
All right. We're going to be back March the 12th, 2024 at 9:30 in the morning. March 12th, 2024 at 9:30. That'll be our permanency review before final order. And there's an opportunity in between now and then, Ms. Reyes, for you to do a lot of work. Ms. Schoaf and Ms. Acevedo, Let's get her into inpatient as soon as we can if she'll go. Miss Reyes, if you don't go, then they can't help you. But that's where you need to be. I don't want you to worry about any of this other stuff right now. I just want you to get to inpatient. I'm not relieving you of the obligation to do it, but that's just the first thing on your list that you need to do. Okay, Miss Kyler Green, have I failed to address anything?
No, Your Honor.
I think I forgot the admonishment. I have to admonish you, Ms. Reyes, that the state of Texas gives you 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for your child. If you cannot do so, your rights to your child are subject to restriction or termination. You're halfway through. You're running out of time.
Your Honor, can I just make one more statement?
Yes.
I just want Ms. Reyes to understand that her child is in a safe place and that she's well taken care of.
Mhm.
And so she needs to get the help that she needs.
She does. I agree. Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, Judge.
Your Honor.
Thank you, Your Honor.